Hear ye, hear ye, hear ye. The Court of Appeal for the 14th District Texas is now in session. Soon to adjourn. God save the Constitution and His honorable court.
Good afternoon and welcome to our Zoom argument this afternoon. We have two cases set for argument. The first one is cause number 14-19-00605, a civil case, Apache Corporation versus Castex Offshore Inc. and other Castex entities. If counsel would make their appearances.
Yes, Your Honor, for the appellant, Roger Townsend, and we're ready, and I'd like to reserve 3 minutes for rebuttal, if I may.
Okay.
Wanda Fowler for the Appalese Castex Corporations.
All right, and our second case on the docket is cause number 14-19-0740, also a civil case, Gator Gone Safety Pilots versus Gary Holt. If counsel would make their appearances, please.
Your Honor, Levon Hovnatanian for Gator Gone, and I would like to reserve 5 minutes for rebuttal, please.
Joshua Davis for appellee Gary Holt.
Okay. We have read your briefs and we are ready for oral argument. And we will start with the Apache Corporation case first. And if Mr. Townsend, if you would wait just a minute and we'll, till you're alone. All right, we are ready when you are.
Thank you, Your Honor. May it please the court. I'm going to try to cover in the short time Potomac liability and damages, as well as a little bit about Belle Isle liability. But I'd like to begin with something the parties agree about. This is from a concession at page 44 of Castex's brief, where they say, here are the words in the question have an ordinary meaning as Apache itself urges. So they're agreeing that willful misconduct has an ordinary meaning. The clear clash between the parties, however, seems to be what is that meaning? In our bench exhibit 1, we've laid that out for you, where they assert that it means any act that accidentally results in injury. And Apache's position is completely the opposite, based on the dictionary, that is not accidental, but it has to be an act with the purpose of causing the misconduct. We have several reasons for that. One is the text of the words, which of course is very important for the party's intention. The parties chose the word willful. They did not say intentional. I think that is because willful is intentional plus, and the something else that it's a plus is a deliberate purpose. They also chose the word misconduct. They didn't choose conduct. They didn't choose act. So based on rules of grammar, the adjective modifies the noun. It has to be purposeful misconduct. We also know that it needs to be given a meaning different from gross negligence, otherwise it would be superfluous. And this is particularly true here when the word gross negligence was already in the model form contract and the industry added willful misconduct later. It would make no sense for them to add another phrase expecting it to mean what was already there. And this raises an interesting problem for Castex, which we show in our second bench exhibit. They have submitted that willful misconduct essentially means some sort of willful, wanton, reckless conduct. But that was exactly, almost word for word, what was submitted to the jury in the question about gross negligence. And the jury said no. So, I mean, a cavalier thing would be to say, if that's what willful misconduct means, we've already got the answer to that. It means no, just reverse the judgment, we all go home.
Well,
but I don't think
no one complained about any conflict between the two answers. So we just evaluate them separately in that case.
That's correct. And I think that's the right answer because they have separate meanings. They can be harmonized along the lines that we suggest. So where do you get the ordinary meaning? We believe it comes from dictionaries. We've given those authorities at page 27 of our opening brief. And even in footnote 4 cited a case from this court doing the same.
But
and there are other
you're
authorities.
Arguing that we should infer an intent to cause harm, right?
An intent to cause misconduct, an intent to create misconduct. And if the misconduct causes harm, I guess that could be a slightly different inquiry. You couldn't recover without damages that caused harm.
Well, how does that then differ from an intentional tort?
Well, intentional torts have both a knowledge and a purpose prong, and I think that's why the industry did not use the word intentional, because it's ambiguous. As the Supreme Court and this court have pointed out, under the restatement, second and third, you can have a knowledge version of intentional, which is you acted with substantial certainty someone's going to get harmed. But there's also a separate purpose form of intentional conduct, where the example is the left jab to the jaw, where your purpose is to cause the harm. And I think that the word willful, based on all the dictionary definitions that both we and the other side have brought forward, indicates clearly that that's what willful means. As Brian Garner sort of succinctly says, it's a voluntary act designed to produce a specific outcome. So it looks at the outcome you're desiring. That's what lifts willful out of the mere intentional, though intentional is broad enough to include it, but I think it's more precise to say willful. And
you do not believe that intentional is higher than willful? Are you arguing willful is higher than intentional?
I think intentional is willful is a higher form of intentional. That intentional can be two things, only one of which is willful. And I think that would be the higher standard, the deliberate purpose to cause misconduct, as opposed to a substantial certainty that it would occur. Now, we could win under either standard here. I'm trying to advise the court on how to write the law to get it correct, because I know the trade usage in the industry is that they view it meaning the operator did the misconduct on purpose, and the utilitarian expectations make sense when you consider them. The drilling for oil is just risky. Maybe the field doesn't have all the gas you think. Maybe the pipe sticks, breaks, something goes wrong 3 miles underground. Maybe gas prices fall while you're in the business. So there are all these risks out there. And I think the industry, supported by the legislature, which authorizes this, wants to give the operator wide latitude to conduct its operations without being second guessed and not having to come into court and spend all our resources litigating at the courthouse rather than trying to produce the gas in the field. So yes, if somebody's grossly negligent or they commit willful misconduct, then the non-operator can sue for that and recover. But you're not supposed to have these little fights about should you have done it this way, should you have done it that way. People can disagree about the data because that's just a waste of resources. And the incentive to retrade, unfortunately, is high when things go wrong, such as here, when the gas field turned out not to be that good, as everybody hoped, and also that gas prices happened to plummet at exactly the same time. So when we sued to collect money they owed us on other projects, suddenly they counterclaimed, seeking hundreds of millions of dollars, and for the first time using the words gross negligence and willful misconduct. I think that's exactly what the exculpatory clause is designed to prevent. But clearly,
when the jury charge says, did Apache's failure to comply result from willful misconduct, who is Apache?
Apache is...
No, I mean, is it an individual? Or does there have to be something more than an individual employee of Apache?
I think because we're under a breach of contract standard, it does not have to be a vice principal as it would in tort, because there you're implying the duty. So I think an individual can breach the contract, but I think the individual has to have the mental state as well as the conduct. I don't think you're allowed, for example, here to take Doug Orr's lack of experience and incompetence in a way, being in over his head, when he's relying on the third-party construction manager, Foster Wheeler, a reputable company, and they start apparently letting things get out of control, and Doug Orr did not know what to do about that. Whereas a more experienced manager who came in later, Ken Moore, would have known what to do about that. And when they try to say, well, why did you assign Doug Orr there in the first place? It's because the outside engineer had originally said this is a $16 million project. That's a lot of money to me, but not to a company like Apache, and really not a lot of money to a company like Castex. The problem was it ballooned from there, and Foster Wheeler didn't do its job. But the irony of this, or the strange thing, is that Castex itself says Foster Wheeler didn't do anything wrong. They're not even negligent. We give you that in bench exhibit number 5, and yet they want to hold us liable for willful misconduct. The real problem Castex has here is that it tried the case as a gross negligence case. People fought tooth and nail over it. There was hardly any mention of willful misconduct. The few times it was mentioned, it was a tag along with gross negligence. And the jury heard the evidence, listened to the arguments, and decided there was no gross negligence. But for some reason, they answered willful misconduct. And now Castex is trying to make the evidence fit under that finding, and it just won't fit. The other example is with Potomac, where their expert admits that we were trying to do it right. We're trying to seal the cement to try to make sure there's no cross flow. In one place, he says, I don't think that I ever necessarily had confirmation of that, but I have here Plaintiff's Exhibit 69, which is in evidence, pages 71 to 73, squeeze cement. They're trying to seal. This is contemporaneous well chronology log. Nobody says it was fabricated after the fact. It proves that we're out there trying to do it. And the other proof is that their own vice president said he would do it again if he had to do over, because people wanted the well to work. We wanted it to work. They say we didn't care because we're selling the property. That actually supports us, because under the closing in November, the effective date was going to be October 1. So the sooner we got the well up and producing, the more proceeds we got to keep. It was only after October 1 that they became property of the purchaser. And we also, in the contract, it's Defendant's Exhibit 702, we had to make indemnities and the usual warranties and all that. So we had no incentive to make things go wrong. Every incentive was to try to make it work. Let me spend just one moment on Potomac damages, because this is an equally flawed area of their case. And if you have the time, I would urge you to read our cross-examination of their expert, Kimbrell. It's in volume 15. It's only 50 pages, and it shows all the flaws in their liability and damages case. He said that we had ruined their reservoir. You can't produce gas there, while Marathon 3 was still producing at the time of trial. It was still producing, maybe slower than it would have been with more wells, but it's there. He also said that CBOP 6 was pristine. That's his own word. Nobody's drilling it because prices are down, but if prices ever go up, somebody's going to go out there and get that gas. He didn't rule out alternative causes of the water. He admits there's water everywhere because this is a coastal area. He admits that 3 of the Marathon wells were producing water even before Potomac number 3 was drilled. How could it be causing water before it's even drilled? And then in our bench exhibit number 4, we've got the chart showing you how he just violates all laws of science and gravity, as well as common sense, when he says that the water dodged a nearby low pressure well, which science says it won't do, went down the hill, up the hill a mile away, dropped around another Marathon well that didn't get water, and then hits the next well over that's higher, and supposedly the water came in from the top instead of the bottom. It's just ludicrous. And the clincher on Kimbrell is page 172. So it's your opinion that the water came from CBOP 1 or CBOP 4 or CBOP 5 or CBOP 6 or CBOP 7. Yes, and it could have come from the original hole or the sidetrack 3. Yes. So there's all these different choices. You just don't know. He says that's correct. And that's what's wrong with his proof. He just doesn't know. He's making it up. I see I'm out of time. I will yield at this point.
All right, thank you.
May it please the court. Just briefly, I want to mention a couple of things. First, this is a slightly new argument on willful misconduct. They have argued intent to cause harm from the beginning. That's what they argued in the trial court. And that's what they're arguing for now, although that was not presented to the jury. No court in Texas has held that the phrase willful misconduct means an intentional tort. No dictionary says, and we have cited 5 or 6 to the court, says that willful misconduct means only intent to cause harm. And again, they've waived the right to make this argument because by not submitting that definition to the jury. Secondly, I want to make a point about the 16.9 and this concept that if someone doesn't know what they're doing, but they hire qualified third parties, it's okay. That everything will be fine. So let's take that to its logical conclusion. Let's put a janitor in charge of the project. If a janitor is in charge of the project and you have 2 qualified third parties, an engineering company and a contractor, is that okay? Or on up. I know that they don't need to be vice principals, but or on up are vice principals. Or new, he had no construction experience whatsoever. Although 16.9 million was a drop in the bucket, literally, for the Apache Corporation, Orr's region, one of 7 with Apache, typically did projects that were 4 times less than 16.9 million. So not only does he know nothing about construction, but he's doing a construction project that's 4 times larger than what his region normally does.
That kind of sounds like negligence as opposed to
all right, so let me say something about willful misconduct. We are proposing that willful misconduct means, and you take the meanings from the dictionary, stubborn misconduct, continuing to engage in misconduct, knowing that you're engaging in it, and knowing that harm may result, and yet continuing to do it. That's common understanding of willful misconduct. That's the phrase that the parties used. It is a higher standard than negligence. But let me get back to how Apache stubbornly continued to mismanage. So this project was so bad that Jeppesen, the executive vice president, had to fire 4 managers who were over this project. Jeppesen felt compelled to tell the CEO, the president, the CFO, the board of directors, and outside auditors about the mismanagement at Belle Isle, because he was concerned that they may need to do some sort of filing with the SEC because it was so bad. Their own management admitted that it was a mess. No scope, no schedule. No one had ever heard of a final cost being 6 times the original authorization for expenditure. No one had ever heard of a person in charge of a project like this having to call vendors to find out what was going on. And they hid the full extent of it from Castex. If you look at tab 5, which we've given you, the first supplemental AFE, it shows that it lists it as 37, essentially 37.7. And again, this first supplemental AFE was not sent to Castex until after they signed the JOA. And Apache indicated to Castex that with this first supplemental AFE, that the project would be done the next month, in November, done, completed. And yet, over $60 million later, was it finally done? That is more than mere negligence. They knew what was going on. They hid it from Castex. They knew the project was completely off the rails and did not, even when they finally, before they finally appointed someone who was qualified, they put a person who has only a high school degree in charge of the project. And only then did they have someone who was qualified, and even then, he was not fully in charge of only Belle Isle. He had other duties. Unless the court has some more questions about that, I'd like to get to the Potomac 3 quickly if I could. The Potomac 3 also reflects willful, intentional, deliberate misconduct, doing things they knew they shouldn't do. First of all, Potomac 3, these were proven reserves. And there's testimony that means there's a 90% chance of recovery, 90% chance of a successful well. Those are high. They knew that the CBOP 5, the entire reservoir was in communication. They knew it was a complex well, a deep well, that they would be going from different pressures, from a high pressure into a low pressure CBOP 5. They designed the well to avoid cross flow and prevent it. Yet they chose a drilling engineer who had never drilled a well this deep, never drilled a well in Atchafalaya Bay, ever, never visited the site. And then in the original hole, they did not fully drill as they intended to, and they knew they didn't. They had the information that told them they didn't drill to where they intended to drill. And yet they stopped it there anyway. And they attempted to put cement around it. They didn't. Let's move to sidetrack 2. Sidetrack 2, and we've attached as tab 9, the email. Although Apache makes fun of this email, it shows that Apache knew there was crossflow, which they refer to as crosstalk. Apache knew there was crossflow that was occurring in the original hole. They knew it. The pipe went through CBOP 1 and CBOP 4, both high pressure water heavy CBOPs into CBOP 5.
Can I interrupt you real quick?
Yes.
For a second? Is it your position that all you had to show was that you just had to identify one person at Apache, one employee of Apache who engaged in misconduct and did so willfully? And if so, who is that person, or who are those persons?
For Belle Isle? Actually, Apache has not, to my knowledge, have not claimed a mix and match theory for the Potomac 3. They've alleged a mix and match theory for Belle Isle. And my position is that or on up knew. But at the latest, in July, Jeppesen, executive vice president of Apache, knew what was happening. He knew how bad the project was. He knew that they were misrepresenting to Castex the full extent of it. So yes, he had the knowledge. With regard to Potomac 3, Jeppesen was the petroleum engineer in charge of that. He knew what was going on. Again, in sidetracks, I just want to get quickly, if I can, to sidetracks 3 and 4. Again, they got stuck. Instead of attempting to put concrete, fully encase the pipes with concrete, they did nothing. They put cement at the very top of the pipe, which did not cover either CBOP 1 or CBOP 4. Their own expert agreed to this. So they deviated from their design 3 times. 3 times they deviated from their design.
Why does that illustrate willful misconduct and not just negligence?
Because it is misconduct to leave it open. Because they knew the issue with crossflow. They knew that crossflow could occur unless they covered the pipes, and they didn't consciously, deliberately, did not encase the pipes in concrete. They just cut them off and went on. And I do think it matters that they were getting out of this. They didn't, in fact, there is a comment from one of the Castex people saying, they just don't care what we think. Also, unless you have some
If I may, I do have a question. So starting with Dan, or it appears that they've gone through, in this case, 4 project managers and 3, or was it 4 engineering firms on the Apache project?
They went through several engineering firms, 2 or 3, yes.
Help me understand. Dan Orr appeared to be incompetent or inexperienced for a project of this size, but he was relying on engineering reports. Does that alleviate his liability or his culpability, his willfulness, if you would, in this project? And at what point did Apache actually become aware of what you want to call mismanagement?
I'm sorry, Judge, are you asking about Belle Isle or
Yes.
Potomac 3?
I'm sorry.
Are you asking about Belle Isle or Potomac 3?
I think it's Potomac 3.
Okay, so Peterson was the petroleum engineer in charge of this, and he received reports constantly, and he agreed that he and possibly others designed the well so that there would be no crossflow from the high pressure SIBOPs into SIBOP 5. By sidetrack 2, so this was a course of about 6 months, maybe 7 months that this occurred over. Sidetrack 2 was done in June of 14. So by June of 14, they knew that there was crossflow, that crossflow was occurring. And he said, we need to stop this. And then by November, the 5th sidetrack was completed.
All right, thank you.
Yes. Briefly, the cases that we submitted to the court show that an expert, this is a classic battle of the experts, just like in Gunn v. McCoy and Windrum versus Carter. Dr. Kimbrell used peer-reviewed calculations. He used the same peer-reviewed calculations that Apache in-house and Apache's outside expert used, except for one calculation, the HVE calculation, which is a peer-reviewed calculation. And although Apache, again, made fun of this calculation, it's an iterative calculation, meaning it is designed for the person to plug in numbers repetitively to determine determine the outcome. And that is what they did here. No expert testified that that was improper. Kimbrell explained that he did precisely what the calculation required. He explained to the jury why he did what he did. He explained why his conclusions were better. For example, he pointed out that the opposing side's expert relied on a number of calculated bottom hole pressures. These were measurements that were taken 17,000 feet above the bottom of the hole, whereas Kimbrell relied only on the actual bottom hole measurements to make his conclusions. This was a 4-week trial. The jury heard conflicting evidence. The expert testimony was backed up. And if I could say just one thing briefly, may I, about the Apache contracts.
Go ahead.
So the Apache contracts, there were 21 Apache contracts. They were defined, specific definitions. No testimony referred to the specific definitions in the charge. No documentary evidence can be related to the definitions that are used in the charge. The testimony that was given was very general and not specific to which Castex entity or which of the 21 contracts we're talking about, nor was the Castex testimony specific as to a Castex entity or contract. The jury, the expert, the person who testified in favor of Apache was unfamiliar with the documents. She gave conflicting testimony, and the jury could have concluded that they just did not meet their burden. We ask that the court affirm the judgment in all respects, and that the court also be mindful of the stipulation that is included in the judgment that also needs to be affirmed. Thank you.
I have one question for you before you leave on question number 2 of the jury charge.
Right.
The failure to comply, did Apache fail to comply prior to any failure to comply by Castex? And there's no material failure to comply in that question. You had the burden of proof on it. So what do we do with respect to that? And do you agree with me that it would have to be a material failure to comply?
I think there clearly is material failure to comply. There was no objection to it on the basis that it doesn't say material.
Okay, but it's your burden of proof, and if the question
and we have clearly met that, Judge.
So you're arguing that it's subsumed within the question, the materiality, basically. You agree
Yes.
that you have to show that. Okay. So then my next question is, do you have to show a grossly negligent or willful failure to comply to excuse your non-payment?
Right. So the case law is conflicting on that. There are in Reader, the Supreme Court acknowledged that the Texas Courts of Appeals, and of course this JOA is a different JOA than this week was discussing in Reader. This JOA is the same JOA that the Courts of Appeals were discussing when they held that for a breach of contract, you don't have to show, the non-operator doesn't have to show willful misconduct or gross negligence. The Fifth Circuit, the Reader Court noted, has held that you do have to prove either gross negligence or willful misconduct in conjunction with to show a breach.
And again, there was no objection to the charge, right?
No objection, no.
And so in the event that we did not think there was willful misconduct in the Potomac JOA, what do we do here with respect to this finding?
With respect to question 2?
Yes. You would argue that it's not.
In other words, you're asking me, you're asking me whether or not you can still hold that there was a breach or
Right.
that they're liable. The jury is out on that. The Supreme Court said no in Reader. This would be one of the Courts of Appeals to hold that you had to prove gross negligence and willful misconduct, and not just was there a breach? Did you just fail to comply? That's the state of the law right now.
Okay, thank you.
You're welcome. Thank you.
Now we'll hear from Mr. Townsend on rebuttal.
Thank you, Your Honor. I want to make 3 quick points. So she's tried to resurrect Kimbrell's damage testimony. Kimbrell admits that he used trial and error method to cherry pick data to find that it was possible for water to get from Potomac to Marathon. That's not good enough in Texas, and that's why it's a no evidence point. She's talked about how they were not informed about the cost. There was a fraud question. The jury answered no. That was both on misrepresentation and failure to disclose. But even maybe more important, this is an authorization for expenditure. The AFE, they said, was false, and they didn't, wasn't accurate. This is an exemplar, but they're all the same form, different numbers. Plaintiff's Exhibit 24. The very first word in the title is estimate. It's not a representation, it's not a guarantee, it's an estimate. And they had the real information from the JIBs. In our bench exhibit number 6, we show that timeline where they had the information. And most important, they kept paying. They even paid the last amount that didn't even have an AFE because they thought the field was going to be so great, as did we. And unfortunately, all of us were mistaken about that. My final point is about the meaning of willful. One last comment. So it occurred to me to look for an analogy. And in the law of false imprisonment, the first element is willful detention. And that is not defined, just like the pattern jury charge says you don't define it in these types of cases. And the Supreme Court has said that willful in that context means you intended to cause detention. It's not you intended to do an act that somehow results in detention. It has to be the purpose that's what you're trying to accomplish. And that fits perfectly with what we've argued all the way through this case about the meaning of willful misconduct. I can't believe it, but she mentioned waiver under her breath when she started. If you just look at the last couple of pages of her bench exhibits, you'll see where we've talked about purpose all the way through. There's no waiver here. That's, if anything, an admission they can't meet the standard of review.
Do you agree that all Castex had to do was just identify a single employee of Apache who engaged in willful misconduct?
Yes, I think as long as the scienter part of it is the same as the conduct, because we're under a breach of contract standard rather than a tort, I think that is sufficient, Your Honor.
Well, in this case, misconduct is the breach of the contract. So, and it's an intentional breach of the contract. It doesn't say anything about intent to cause harm.
I think we're miscommunicating slightly. I'm not saying intentional breach of contract. I'm saying purposeful misconduct, which would mean purposeful breach of a purposeful failure to comply.
Well, the failure to comply is the breach of contract, right? And in particular, with respect to Potomac, that is to act as an operator with reasonable, as a reasonable operator does. So it's not intent to cause harm, it's intent to not act as a reasonable operator.
No, it's you have to have the intention to do misconduct.
Well, misconduct is the breach of contract.
I don't think a simple breach of contract necessarily meets that standard because that's the quibbling you can have whether you did it right or not. That could be a breach, but you have to have the purposeful desire to do it. The example would be falsifying an invoice. You're doing that on purpose, or some disgruntled employee for whatever reason purposefully damaging the well. That is purposeful misconduct. Mismanagement is the usual phrase for misconduct. And that's what has to be on purpose. If they wanted to say intentional breach of contract, that's what they would have said.
I mean, you're saying willful mismanagement. Okay, well, mismanagement means that you didn't, with respect to, you didn't act as a prudent operator. That's the mismanagement. I disagree with you. I don't think that's the same standard. Well, how are you defining misconduct then?
I'm defining it as mismanagement or a breach of duty with dishonesty, which is one of the connotations. But I don't think a simple breach of contract is necessarily rises to the level of mismanagement. It may not matter here because I don't think they can show an intentional breach of the contract. She was a little loose with the facts in her recitation of what was going on out there. Peterson's testimony explains that if he went too far, he would do the very thing that they're complaining of. He's out there for 12 hours reading well reports that are coming in 30 minutes later because they're so far underground. And he's always about 60 feet behind where the bit is. So you want to be extra careful. And Kimbrell finally admitted that people can just disagree about the data. He, in hindsight, with more tests that he admits were not available at the time, he says, yeah, well, I think they could have gone further. And our guy, being cautious, did it short. And that's exactly what the exculpatory clause says. You don't get to litigate that. That's just one of the risks of these types of projects.
Any other questions? All right, thank you very much for those interesting arguments. Apache versus Castex is submitted, and we will now hear from our second case. All right, I don't think we need Mr. Davis here because I've already called the case. So we'll put you back in the waiting room.
Thank you, Judge.
All right, and we are ready for, can you pronounce your last name for me again, please?
Of course, Your Honor, it's Hovnanian.
Hovnanian. We are ready for you.
I think you just said it better than I ever have.
No.
May it please the court, my name is Levon Hovnanian, and I represent the appellant in this case, Gator Gone Safety Pilots. Justice Catherine Stone, writing for the San Antonio Court of Appeals in Board of Adjustments versus Kennedy, wrote in the very first sentence of her opinion, the standard of review in an appeal is literally always important, but sometimes it's downright critical. Sometimes it can tell the tale almost by itself. Justice Stone wasn't talking about factual sufficiency or legal sufficiency, but I think her words also apply here because I think the standard of review is the most important part in this appeal. There is no way that Mr. Holt can show this court that there is literally no evidence to support what the jury did in this case, to support the jury's verdict. On the contrary, the record contains abundant evidence to support the jury's allocation of 15% of the responsibility on Gator Gone. The first category of evidence to support my argument is Heidi LeClaire's testimony herself. She testified repeatedly that when the pole car went through the intersection, her pole was exactly at 19 feet. She was questioned on that, by Mr. Davis repeatedly, and always said, look, it was 19 feet. In addition to that, Centerpoint measured the pole. The evidence is that Centerpoint arrived at the accident scene within 30 minutes of the accident. They measured the pole. They found it to be exactly 19 feet. That's in the record in several different places, mostly documentary evidence, but also the testimony of Pam Davidson, who said, I was there and I watched them, and Centerpoint measured the pole and hit 19 feet. Now, if the court agrees that that is some evidence, more than a scintilla of evidence, that Ms. LeClaire's pole was 19 feet when she proceeded through the intersection, then the JNOV cannot be correct. It cannot withstand the court's no evidence review, and the judgment notwithstanding, the verdict should be reversed. But
Well,
of
I
course,
guess my understanding of just the argument is that if her pole was at 19 feet, this accident could not have happened.
Your Honor, but the problem is that's certainly Mr. Holt's evidence, but there's nothing that Mr. Holt can show this court that binds the jury. In other words, Mr. Holt can point to expert testimony from Ms. Singh and Mr. Swanson, but that expert testimony did not bind the jury, and in fact, there were gaps in it. One such gap was Mr. Swanson's own calculations being characterized as a guesstimate. Mr. Swanson stating that he believed, quote unquote, that the measurements were still accurate, even though the accident happened in 2015 and his measurements were done in 2014 and 2018. The fact that Mr. Swanson also said he was between 95 and 99% sure, not 100% sure. This court held in P&S Stores in 2016, and the Texas Supreme Court held in McGalliard in 1986. There is no case in which expert testimony will bind the jury. The jury is free to believe lay testimony and to disbelieve expert testimony. So we respectfully suggest Mr. Holt's evidence doesn't control and doesn't change the outcome in a no evidence review. That would be our argument, even if his evidence was airtight, but it's far from airtight. And that's an additional reason that the jury could say, you know, this is a case where there's pretty bad damages. 95 to 90% to 99% is not going to satisfy me. And over here, however, I have several lay people saying that pole was at 19 feet. And I'm going to believe the rock solid lay testimony from witnesses who were there, as opposed to experts who equivocated with a guesstimate years after the fact.
But
So
no,
there was,
go ahead.
go ahead. Okay, I didn't mean to interrupt you. I had a question about, there was some discussion in the brief about high winds or potholes and so forth in the street. So can you cover that for me, please, to give me an idea of what the jury might have believed in terms of whether the load could have struck the line even if the pole was at 19 feet?
Of course, of course. There was abundant evidence, some from the police officer, some from the witnesses. They all testified, and this is a quote from one of the witnesses: the load was rocking side to side due to the potholes and slant of the road. There was abundant testimony that the road was not even. There was a slant to it. There was testimony that there were potholes and that there were bumps in the road. One of the witnesses even said humorously, when she was asked, you know, what was the condition of this road, her first response was, well, it's a Houston feeder road. And so it had potholes, it had bumps. In addition to the road being in poor condition to where the load was actually rocking from side to side, there was also evidence that it was windy and gusty that day. Now, it is true, Ms. LeClaire testified, her pole doesn't bend in the wind, but that doesn't account for the wind. The wind could have blown the wires down to less than 19 feet. I don't know if it did or it didn't, but the jury was entitled to conclude that it did. The jury could have also concluded with the load truck bouncing up and down that by the time it got under the wire, it had bounced higher than 19 feet. And so that's why it hit the wire. And of course, all this culminates not just in Ms. LeClaire's theory, but actually in what the police officer who wrote the report concluded in his report. This is a quote from the report. He said the accident was probably the wind, the cause of the accident was probably the wind and the lean of the road. Now, if the court concludes that the jury was entitled to believe that whether the pole was at 19 feet or not, this accident was caused by the wind or the condition of the road or both, that is more evidence that undoes the judgment notwithstanding the verdict. Because the judgment notwithstanding the verdict says Heidi LeClaire is 100% responsible, or Gator Gone is 100% responsible. So if there's anything in this record where the jury was entitled to conclude, no, she wasn't, she was 15% responsible, then that should nullify this misbegotten judgment notwithstanding the verdict. But there wasn't just Ms. LeClaire's testimony, and there wasn't just the conditions of the road and the wind. And by the way, let me pause. Mr. Holt has in the record a wind speed report. And the wind speed report says on that day and at that intersection, there were no high winds. But just like the pole's height, 19 feet or less, that's a credibility determination for the jury. The jury could have said, I disbelieve the witnesses who were there, who said it was gusty and there were high winds, and I do believe the wind speed report. But the jury could have also said, I don't believe the wind speed report, and I'm going with the eyewitness testimony from people who were actually at the scene of the accident. That's a credibility determination for the jury. So we're not saying there's no evidence in the record to support Mr. Holt's argument. We're just saying he loses anyway, because there is abundant evidence in the record that Heidi LeClaire was not 100% responsible for the accident.
Let me ask you a question about your position as to Bennett.
Yes, Your Honor.
So as I understand from the brief, you rely heavily on Plaintiff's Exhibit 11 and the permit form. And one of the statements in the permit is that the applicant accepts all responsibility and liability for damages resulting from movement of the load on the state highway system. And so my question is, does that statement impose an obligation or a liability on Bennett for to all third parties, or does it impose an obligation or liability as to the state with give a protection to the state?
And Your Honor, the answer is all third parties. And it's because the key language in there, and I don't like to read to the court, but this is so important. It says accepts all responsibility and liability for all damage resulting from movement of the described load on the state highway system. All damage does not mean just the damage to the state or to the federal government. All means all. And in fact, that's a quote out of a case, believe it or not. And so it would include damage to an innocent motorist like Mr. Holt. But even if that weren't true, the next sentence in there, which says it is the responsibility of the permittee, which everybody agrees that was definitely Bennett, to clear any overhead obstructions or utility lines, is to me more important than the first one, because that actually specifies overhead obstructions and utility lines or utility lines. Well, there's no question in this case that the power line, the live power line that snapped and damaged Mr. Holt was a utility line. If it wasn't, it certainly was an overhead obstruction. But either way, that's what caused the damage in this case. And that's what the jury heard, that it's Bennett's responsibility, it's Bennett's liability. One other thing, Your Honor, too, is we don't ask this court to look at Plaintiff's Exhibit 11 in a vacuum. The fact of the matter is, this was Bennett's transport. Mr. Jones testified for Bennett. Mr. Jones, was in 100% control. That's his quote, 100% control. And he specified from the time the permits were obtained all the way through the end of the transport, including the ability to terminate people from their jobs on the transport team. So this PX11 has an important context. It was Bennett's load. It was Bennett's responsibility. Now, it's true that we rely on PX11 But there's more to the 70% finding than that. There's also the fact that despite the fact that this was Bennett's load and Bennett's responsibility, Bennett never checked the height of the pole during the trip. That applies to VersaBucket too. There was testimony that VersaBucket had the responsibility to check the height of the pole during the trip. Neither Bennett nor VersaBucket did. There was even testimony in the record on how to do that. VersaBucket or Bennett could have pulled over to a place that was safe to stop for the whole transport to stop, gotten out the tape measure, even Ms. LeClaire had a tape measure, measured the pole, determined it's the right height, or if not, adjust it and move on. It would not have been complicated. And yet VersaBucket and Bennett, neither one fulfilled their duty in this regard, which is another reason that there's evidence in the record Ms. LeClaire was not 100% responsible for this accident, and the jury could have put responsibility on Bennett and on VersaBucket.
All right, we'll let you have rebuttal time, and we'll now hear from Mr. Davis.
Thank you, Your Honor.
We're ready for you.
Thank you, Judge, and may it please the court. My name is Joshua Davis, and I represent Gary Holt in this matter. I'm going to divide my time today first discussing the factual issues raised by counsel and certainly in their briefing, and how City of Keller applies to our evaluation of those factual issues that lead to support the trial court's JNOV. The second half will spend talking about a fictitious counsel-created legal duty in closing argument that appellate counsel just finished discussing that is simply non-existent and should not be the basis for anything, much less supporting appellant's position, Gatorgaun's position, about overturning the trial court's correction of the impact that that improper argument had in the minds of jurors. I want to direct the court to the record, the reporter's record, volume 3, page 6, line 24 through page 7 through line 13, but I'm only going to read a short part of it, and I appreciate reading to a video camera is unhelpful at times, but for this testimony from Ms. LeClaire, who is the principal of Gatorgaun, right? She owns that company. She was asked, and at the time that you were going through the intersection, you did not have any significant sort of bumps or movements in your vehicle that might indicate that your clearance of the wire would potentially have been the result of the bumps or movements in the roadway. Fair to say? Answer, yes, that's correct. Question, and then you were not at this time experiencing any significant wind that would have been blowing your pole or bending your pole because it's made of fiberglass. That when it cleared the wire, that somehow it was clearing it because it was being bent over from the wind, correct? Answer, no, my pole doesn't bend in the wind. Now, counsel referenced that comment, but he fails to look to the City of Keller and how it breaks down evidence that cannot be avoided when a JNOV or a no evidence motion is made, and this is such evidence. Ms. LeClaire's affirmative, definitive statement that it wasn't bumpy in the roadway and the wind does not affect my pole must be evaluated as true. Counsel references the police report and the statement by Ms. Davidson. The police report is based on the statement by Ms. Davidson, and that's reflected in the record. Ms. Davidson, who is the mother-in-law of Ms. LeClaire, was following not just behind the pole car, not just behind the bucket truck, not just behind a 19-foot wide, 18.5-foot high load, but behind that further. And it was her testimony about, quote, wind and roadway conditions that could have created the condition to allow a 19-foot pole to pass through unimpeded while an 18.5-foot load struck the communication line. City of Keller tells us that evidence can't be viewed out of context. We have to contextualize it within the record, and we have to assess the circumstance of the testimony, in this case, being offered. The house that council wishes to build upon the wind and roadway condition defense is solely built upon Ms. Davidson's discredited testimony. So discredited that if you look at closing argument from Gator Gone, in 30 minutes worth of closing argument, he spends exactly 3 seconds, possibly, 1 sentence of his closing talking about wind and roadway conditions, and he doesn't make it an affirmative statement even. He poses it as kind of a hypothetical or possible question because he likely would have drawn an objection given the way that the record delivered the truth about the matter of the wind and the roadway. They did not in any way impact a 19-foot pole, supposedly, going through an intersection in which an 18.5-foot load caught it. And think about that truth, right? I heard your prior arguments of counsel in the prior case. The court is free to accept and take judicial notice of basic math facts. To have a 19-foot prone, a fixed line equivalent to 19 feet pass through a space designed for, let's say, 18 feet 6 inches or 18 feet 5 inches. That 19-foot pole has to be moved over on that axis by a significant degree. And we know that contextually, that is required to be accepted for their alternative theory of liability to be proven. Because her act of calling clear is the act that proximately caused the event. It wasn't the load moving through the roadway, because Ms. LeClaire testifies, everyone testifies, the driver, Mr. Jones, has no ability to know if his load is going to impact something because of his vantage point relative to the load. The sole job for which the pole car is hired is to strike things that may impede the load. That's the only reason why that job exists. And that is the only reason why that independent contract bid was made, to try and strike things that the load might impact. And so if we accept as true that the pole could not have been 19 feet, and that must be true based on the physical evidence, it must be true. And we cannot account for the defense they offer on appeal now that it was the wind or it was the roadway, because they have affirmatively judicially admitted that's not possible. Counsel's suggestion that somehow the load, that is tons, and like the tonnage of this load is in the record. It is an extremely heavy load. To suggest that somehow the intersection that Ms. LeClaire went through as she passed underneath the nadir of the communication line, because she testified, yeah, I go to the lowest part of what I see to pass underneath that lowest part. That's what I do. Well, if she goes under the nadir of the communication line and her pole's at 19 feet, it must strike. But even if it doesn't, they say, and even if it is or isn't at 19 feet, let's presume that somehow the load was manipulated to such a degree by wind or the roadway that it tilted such that it was angled to capture some part of the communication line. Again, that is pure speculation on appeal. There is zero evidence in the record to even offer that statement. No engineer suggested as such. No party has suggested as such. They didn't even argue that at the lower court. So I don't know how we are to presume that the jurors could have concluded that is the possibility for which we can assign 70% liability to Bennett, given that there is zero evidence in the record. Now, counsel quoted the San Antonio Court of Appeals case in his opening. In that statement, he is saying that the standard is all that matters. Well, the standard is well outlined in City of Keller. And City of Keller does not in any way suggest that we have to somehow demonstrate a complete and total absence of all things that would otherwise support the JNOV. That's not the standard. And that's why City of Keller goes through so clearly and succinctly all of the different pieces of evidence and how they must be evaluated within the context of the record. That's why you have certain pieces of evidence that the court can never ignore, right? Like admissions by a party. You have pieces of evidence that may be ignored. You have conflicting pieces of evidence for which both can be true and it does not matter. But if you apply City of Keller to these arguments that are based in fact, they all fall away based on the entirety of the record. Think about the only two pieces of evidence that they're relying upon on the wind and the roadway have no real evidence when placed into context of the full record. I mean, counsel talked about the fact that we very early on got the wind statement for that place on the earth for that exact time and day, demonstrating that the wind was not particularly significant. Well, counsel wants to now rely upon the testimony of Miss Davidson about the wind, despite Miss LeClaire's own testimony that it had no impact, and despite recorded data. This is, to analogize, like a neighbor saying that, oh, Mr. Homeowner, your roof was damaged because of wind. I saw it.
So,
and the homeowner...
Mr. Davis, the
Yes,
fact that the jury answered yes as to Gator Gone indicates that they did not think that her poll was at 19.
I don't know that it indicates that exactly. I can't.
What else would be the negligence of Gator Gone?
I think the way that it was being argued in closing was it's partially everybody's fault. Let's throw everything against the wall and see what sticks. The buck stops here, defense.
But it's your obligation to prove Gator Gone is 100% responsible.
Correct.
And so the jury, by putting 15% on Gator Gone, must not have thought that her poll was at 19.
Again, I don't know. I'm not speculating on that.
Under your theory of the case, that it's not possible for the accident to have happened if her poll was at 19. Okay.
Right. That's correct.
So then, therefore, if the jury is believing your theory of the case, they have to have believed, or your, what you say is uncontroverted evidence, they had to have believed that the poll wasn't 19.
And that may very well be true. I don't know that I need to get into the details of that issue. My point there is
but
the 70%.
Because you have to prove that there is no evidence that Bennett was negligent and no evidence that a Versa bucket was negligent. That's what you have to prove.
Correct, Your Honor. And there is none.
Uphold your JNOV. That's what you have to prove.
And there is none. There's none. When she calls clear, when LeClaire calls clear, after her poll proceeds, because it was not at 19 feet, that is the negligent act that proximately causes the event. LeClaire testified that once she calls clear, there is nothing for the bucket truck to do, and there is nothing for Bennett to do. The bucket truck proceeds because she has not impacted anything that the load might impact that the bucket truck would need to intervene with respect to. And that's their job. That's their only job per their contract. Bennett, likewise, is in no position to do anything but proceed because she has called clear.
Can you discuss the stripping? Didn't Versa bucket do the stripping on the loads?
Yes, it did.
And can you explain what that is and how it was fixed after the accident?
Well, Your Honor, you use the word fixed. There was nothing in the record to demonstrate the stripping failed in any way. So they did extra stripping after this happened, because at that point in the transport, there was no evidence that the pole had been falling or could fall. This was the first instance of the pole falling. So bear in mind, the record demonstrates multiple instances in which the pole fell subsequent to this event, leading everybody to clue in on that pole is not meeting its right height every time. So, but going back to the stripping, it's just that the bucket truck gets up on the load prior to the load's movement and uses some essentially kind of PVC pipe and stretches it over the load from back to front so that the movement of any wires or low-hanging tree branches kind of slide along those PVC pipes as the load passes by. But the stripping in no way adds to the overall height of the load, and that's been testified to uniformly. And there's zero evidence that the stripping caused any issue at all with respect to this event. And that's why you don't see any closing arguments on that point. They never argued that somehow the stripping messed up, because there's zero evidence that the stripping messed up, added to the height of the load improperly, or was somehow manipulated to the point that it created a circumstance that would impact the communication line. So again, but that just goes to the point of taking the record as a whole. And I see I'm close to running out of time, but I want to get to this issue, especially because Justice Jewell, you asked about it concerning Plaintiff's Exhibit 11. We cannot, that is lawyers, cannot in closing argument create brand new legal duties like the one espoused by appellate counsel. There's no ability for us to do that. Neighbors said,
Let's assume that Plaintiff's Exhibit 11 created no duty on Bennett.
Sure, because yes.
The charge says that everybody had a duty of ordinary care, just in tort. So why would that not be so here as to all three of the defendants?
I'm not understanding your.
Well, I mean, you're not arguing that Bennett lacked a duty in ordinary care, are you? Or that Versabucket lacked a duty?
No,
your position, as I understand it, is that Gatorgon's conduct was the sole proximate cause, right?
That's definitely true.
And that
when we talk about, sorry,
and that Bennett and Versabucket did not breach their duties that they owed.
No, of course not, because this was a independently contracted transport team for which each independent contractor had a specified role that they were in charge of. And to your Honor's question, we cannot proclaim a generalized duty of ordinary care about an event that presupposes other witnesses to the acts of an independently contracted pole car would think her pole's not at the right height for no reason whatsoever. And that was this first event. If this event occurred, hours or days into this transport, and they already had multiple instances in which Leclerc's pole had slipped, right? Then I can appreciate that possibly we can say there is a generalized duty and a duty of ordinary care on the other transport members to be very conscious of Leclerc's pole potentially slipping. But the uniform 100% evidence is this was the very first time. And if that's true,
but then there's no negligence on Leclerc unless you're making it a strict liability situation. If she didn't know that the pole had slipped.
Your Honor, she's contracted to do that. Whether she knows it slips or not does not somehow mean she's not required to be the pole car driver that has a pole that doesn't slip from 19 feet. And that's why when she gets those clamps that she testified she bought to, by the way, in her second deposition after we had to file a motion for sanctions relative to the perjuring testimony from the first, when she testified to buying those clamps about the pole slipping, that solved the problem completely. But to suggest that somehow I have to prove specific intent with respect to her knowledge, that's the gross claim. That's the gross question. She had a duty to drive a pole car at 19 feet. And if it slips, whether she knows it or not, that's negligence. And especially to the extent that it slips, that's
strict liability. That's not negligence. If you're saying her duty was to have it there, whether she knew it or not.
Her duty was to have a 19-foot high pole car and drive it during the load. That's her duty, period. Whether she knows it's not at 19 feet because it slips, that I don't have to prove that she knew it wasn't. No way. No way. And to the extent that that's somehow the created standard, then no one was negligent at all for this whole event. And that's also not, the record doesn't speak to that either. No, she doesn't need to know that she wasn't driving her pole at 19 feet when this occurred. No, I think I've never, and it's not strict liability. It's that her duty was accepted when she bid for the job, and they said, we need your pole to be at 19 feet because we've got an 18-foot, 6-inch load, and you're the pole car driver. And presumably you got the equipment necessary to do all of this without having it accidentally slip. It doesn't have to intentionally slip or knowingly slip. That's not the standard.
All right, thank you very much.
Thank you.
Your Honor, may it please the court, just a few brief points on rebuttal. First, to follow up on Justice Jewell's question, the jury question in this case on negligence was a broad form jury question. So in answering that broad form jury question, could the jury have looked at Plaintiff's Exhibit 11 and determined, yeah, I think this is some evidence of negligence without the broad original question of is there a duty? And the answer is yes. The law is clear on that when there is a broad form jury question, as we had in this case. Even if I'm wrong about that, the fact is Plaintiff's Exhibit 11 was Plaintiff's Exhibit 11. It was Mr. Holt's exhibit. It came in without objection. It came in without limitation. The argument that Mr. Holt is saying was improper is a 100% accurate reading to the jury of the wording of Plaintiff's Exhibit 11. That is very clear. Gator Gaughan's trial counsel didn't do anything improper with Plaintiff's 11. All he did was read it to the jury. Now, what the record doesn't show, however, is a ruling on Mr. Holt's objection to that argument, nor does it show an instruction that the jury should disregard that argument, which means we have, number one, a waived issue, and number two, an issue that's also wrong on its merits, because the argument about PX 11 was little more than just a reading of PX 11. And the record clearly shows that. The second point I want to make is Ms. LeClaire, and this is in volume 2 of the reporter's record on page 252, specifically said that the pitch of the road could have caused the accident. Everything Mr. Davis said today about what Ms. LeClaire testified about bumps, all that was true. All that is true. She still said, however, again, volume 2, page 252, the pitch of the road could have caused the accident. And my last point is the correct disposition in this case. The evidence is factually sufficient to support what the jury did. Because that is true, this case is not one that would be appropriate for reversal and remand for a new trial, but instead it's appropriate for rendition of judgment in accordance with the jury's verdict. The only other point besides factual sufficiency.
Wouldn't we instruct the trial court to render judgment on the jury verdict, and then, motions for new trial will be filed after that?
Your Honor, respectfully, and I don't want to tell the court its job, but respectfully, I don't think so. Because of the rule of appellate procedure that says the Court of Appeals is to render the judgment that the trial court should have rendered. And applying that rule here, to me, it seems that the court would render judgment in accordance with the jury's verdict, not remand it to the trial court, but instead the court would render judgment itself. The court would have to, of course, first determine that the evidence is factually sufficient. We're very confident it will, because of all the evidence supporting what the jury did.
Has a factual sufficiency point been raised, though, here?
Your Honor, I suggest it has not.
Okay.
I'm addressing the merits first and waiver second, and maybe that's a little backwards. I suggest it's been waived because it's not briefed in Mr. Holt's brief. He doesn't discuss the standard of review. He doesn't apply the standard of review. There's nothing to show in his brief. There's no argument that the evidence is factually insufficient. And the truth of the matter is the evidence was abundantly factually sufficient because of the various ways the jury could have apportioned liability in this case, not just to Ms. LeClaire, which we don't run from, but also to VersaBucket and also to Bennett. So the other argument in favor, in Mr. Holt's brief, in favor of a new trial is improper jury argument. And I've addressed that. That's a waived point and it's wrong on the merits as well. So for all these reasons, we ask the court to reverse the JNOV and for this court to render judgment in accordance with the jury's verdict.
Thank you very much. The case of Gator Gone versus Holt is submitted and we are adjourned. Thank you for your arguments.
Thank you.